Народно-освободительное движение Союза Советских Социалистических Республик.
The Soviet of Ministers of the USSR, State Committee on the State of Emergency. Date, September 4th, 2023. By the right of the sovereign. Decree. The great sovereign country, the Union of Soviet Socialist Republics, represented by the State Committee for the State of Emergency of the USSR, SCSE of USSR, as the supreme state authority of the Union of Soviet Socialist Republics, on the basis of the laws of wartime, expresses its respect to the all great, united, sovereign Soviet people, all the subjects of law and the entire world community. Hereby approves and proclaims the First Congress of Citizens of the Union of Soviet Socialist Republics, expressing the will of the great, united, sovereign Soviet people to preserve the USSR, expressed at the referendum on March 17, 1991, considering the difficult situation in the USSR and the violation of the Constitution of the USSR of October 7, 1977. Basic Law. In Decree No. 1 of December 30, 1991, he did not recognize the signing of the Belovezhskaya Accords. By his decision, he transferred full power, legislative, executive, and judicial, and the entire sovereign territory of the great sovereign country, the Union of Soviet Socialist Republics, to Military People's Council of the USSR, MPC of the USSR. On the basis of the decree of the Military People's Council of the USSR, GP of USSR, number 33 dated March 23, 2023, Order number 30 of the People's State Authority of the Sovereign International Consumer Cooperative Light Great Russia, the State Committee for the State of Emergency of the USSR was created. On the basis of the decree of the Supreme National Assembly of the USSR number 35, dated April 24, 2023, was approved as the supreme authority of state power of the great sovereign country, the Union of Soviet Socialist Republics, according to the laws of wartime. Sovereign International Consumer Cooperative Light Great Russia, as the People's State organ of the Union of Soviet Socialist Republics, Decree of the Military People's Council of the USSR No. 174 SPK, dated September 30, 2018, and State Treasury of the Union of Soviet Socialist Republics, whose functions are performed by the Sovereign International Treasury Monetary One, Decree of the Military People's Council of the USSR, DP of USSR, No. 81-6, dated October 7, 2018, on the basis of the Decree of the Military People's Council of the USSR, PVK 33, dated March 23, 2023. The state company Russian Federation, Russia, was re-registered from the Anglo-American jurisdiction to the jurisdiction and to the state register of its absolute owner, the sovereign country of the Union of Soviet Socialist Republics, during the re-registration of the state company Russian Federation, Russia. The status of the company Russian Federation, Russia was determined as a state cooperative enterprise of the great sovereign country, the Union of Soviet Socialist Republics. According to the Sovereign Legal Act that has entered into legal force, the decree of the Military People's Council of the USSR, PVK 33, dated March 23, 2023, there are no other active subjects of law with the name Russian Federation, Russia. The State Committee for the State of Emergency of the USSR, SCSE of USSR, as the supreme body of the state power of the Union of Soviet Socialist Republics, declares, approves, decides, and notifies that in the existing legal circumstances of the sovereign territory of the great sovereign country, the Union of Soviet Socialist Republics, there are no legal grounds for holding any elections, voting, plebiscites, electoral consultations for sovereign citizens of the great sovereign country, the Union of Soviet Socialist Republics, as deceived citizens who are misled about the presence of false citizenship of criminal, separatist, predatory commercial corporations, Republic of Azerbaijan, Republic of Armenia, Republic of Belarus, Republic of Georgia, Republic of Kazakhstan, Kyrgyz Republic, Republic of Latvia, Republic of Lithuania, Republic of Moldova, Republic of Tajikistan, Turkmenistan, Republic of Uzbekistan, Ukraine, Republic of Estonia. In connection with the occupation of the sovereign territory of the USSR, genocide, oppression and robbery of the multinational sovereign people through extremism, terrorism, poverty, hunger, the introduction of GMOs, sacrifices, slave trade, murders through the sale of organs, on the basis of Article 121, paragraphs 15-16 of the Constitution of the USSR. Paragraph the 1st, Decrees of the First Congress of Citizens of the Soviet Union No. 1 of December 30, 1991. Paragraph 8 of the Mandate of Trust, No. 1 of December 30, 1991. The Permanent Presidium of the Military People's Council and the Council of Defense of the USSR, at the plenary meeting on January 13, 2020, issued a resolution of the USSR General Prosecutor No. 36, WPM, on the declaration of martial law on the entire sovereign territory of the Union of Soviet Socialist Republics, and the results of voting and various kinds of elections in the state cooperative enterprise Russian Federation, Russia, as well as the other commercial corporations, Republic of Azerbaijan, Republic of Armenia, Republic of Belarus, Republic of Georgia, Republic of Kazakhstan, Kyrgyz Republic, Latvian Republic, Lithuanian Republic, Republic of Moldova, Republic of Tajikistan, Turkmenistan, Republic of Uzbekistan, Ukraine, Republic of Estonia, formed on the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, as a result of violation of the will of the sovereign Soviet people, are invalid and are considered falsified and criminal, which are not state, republican, and country, therefore cannot have legal effect. Voting, elections, and referenda are not possible until the abolition or removal of the emergency regime and martial law throughout the sovereign territory of the USSR by issuing a special and emergency decree of the SCE of the USSR. The State Committee for the State of Emergency of the USSR, as the supreme state authority of the Union of Soviet Socialist Republics, declares, approves, decides that throughout the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, the standards of the USSR continue and operate, which do not allow the application of standards that are not provided by the state executive body of the Union of Soviet Socialist Republics, carrying out the functions of development, state policy, and legal regulation of the sovereign legislation of the USSR. Information and technological systems of the state cooperative enterprise Russian Federation, Russia, such as Goschain, Master Chain, as well as the similar systems of other commercial corporations, Republic of Azerbaijan, Republic of Armenia, Republic of Belarus, Republic of Georgia, Republic of Kazakhstan, Kyrgyz Republic, Republic of Latvia, the Republic of Lithuania, Republic of Moldova, the Republic of Tajikistan, Turkmenistan, the Republic of Uzbekistan, Ukraine, the Republic of Estonia, formed on the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, for electronic voting are illegal and invalid. Voting results forged and falsified by foreign occupiers at different times, which do not allow issuing one of the voting results as the only reliable one, are cancelled and invalid. The processing of such electronic information and the transfer of this information to foreign states is an act of high treason and a war crime in the entire sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics. Based on the studies of several institutions of the State Service of the Union Anti-Terror of the State Security Committee of the USSR, during the period of occupation by foreign corporations since 1991, our great motherland, the Union of Soviet Socialist Republics, there were no popular democratic elections. The last legal referendum took place on March 17, 1991, by which the majority of citizens of the USSR, forming the United Multinational Sovereign Soviet People, as the all-union referendum, voted for the preservation of the USSR. The results of the referendum were fully recognized by the world community. By the right of the sovereign, on the basis of the norms of international law, the sovereign legislation of the USSR, the State Committee for the State of Emergency of the Union of Soviet Socialist Republics, as a state military and political body of the special composition of the Special Presence Conference, with expanded powers as a sovereign country, the Union of Soviet Socialist Republics, as a supreme body state power of the Union of Soviet Socialist Republics, on the basis of the laws of wartime, hereby approves and proclaims any person or elected assembly declaring or formed on the basis of the results of pseudo-elections, voting, Plebiscites, electoral consultations in the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, will have an insignificant and invalid status, or will indicate that such a person by elective assembly is formed temporarily, limitedly, without the right of the state, legislative and representative body of power in the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, but exists as a criminal, false, self-proclaimed body, the holding of all kinds of pseudo-elections. Voting confirms the fact that officials and substitutes in all subjects of the law of the Great Sovereign Country, the Union of Soviet Socialist Republics, have committed violations of the current and applicable sovereign legislation of the USSR, exposes them as criminals guilty of committing criminal, state and war crimes, and also an attempt to seize the lawful power. Law of the Union of Soviet Socialist Republics, dated April 2, 1990. Number 14031, which are administered by the special meeting of the Military Tribunal of the Union of Soviet Socialist Republics, and in the jurisdiction of the sovereign state laws of the Great Sovereign Country, the Union of Soviet Socialist Republics, according to the laws of war and wartime. These criminal acts are subject to criminal liability for treason to the motherland, sabotage, decree of the Presidium of the Supreme Council of January 11, 1984, terrorist acts, reckoning, decree of the Presidium of the Supreme Council of May 18, 1961, as separatist, extremist, and terrorist international crimes. Any foreign state that has recognized the results of invalid and falsified votes, or various elections in all subjects of law or the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics, in violation of international law and non-observance of the legal norms of international justice and continuity, recognizes its interference in internal affairs of the Great Sovereign Country, the Union of Soviet Socialist Republics, and is defined as a proven and established legal fact as an international, separatist, extremist, and possibly terrorist crime. This decree has the status of an absolute sovereign legislative act and is subject to full mandatory implementation through the sovereign territory of the Great Sovereign Country, the Union of Soviet Socialist Republics and beyond, in the entire world space, in accordance with the law of the sovereign legislation of the USSR, and the international rules of law. In the event that any subject of law and any subject ignores this decree of the State Committee for the State of Emergency of the USSR as the high state authority of the Great Sovereign Country, the Union of Soviet Socialist Republics, this subject of law is recognized as criminal, belongs to the category of separatist, extremist, and international terrorist. This decree comes into force from the moment of its signing. Om. Chairman of the State Emergency Committee of the USSR, Army General B. Satushev. Commissar of the State Emergency Committee of the USSR, Lieutenant General A. Chernomorov. Secretariat of the State Emergency Committee of the USSR, Major General I. Горбачёва.
Народно-освободительное движение Союза Советских Социалистических Республик.